Welcome to the CCHR Florida talk show. My name is Håkan Johansson. I have with me today Tina Willis, an attorney. You're in private practice in Central Florida.
Yes, sir.
I'd like to ask you something that has come up on the CCHR Florida hotline more than once. Parents are about to be divorced. They decide to put, one of them decides to put the child on a psychiatric drug without the consent of the other. What are the rights of the other parent, and what can that parent do?
Well, if they haven't already, they need to file a petition for dissolution of marriage, and then what often follows from there, if children are involved, is what we call a shared parental responsibility agreement. And as part of that agreement, in the overwhelming majority of cases, parents must collaborate and attempt to make joint decisions. So it would be a violation of that kind of agreement to put the child on medication without the other parent's approval. Now, if the parent has gone ahead and done that and put the child on medication, then first I would advise the other parent to contact the physician and let them know that this parent is not willing to allow their child to go on medication and that there's a shared parenting agreement in place. You want to be nice to the doctor when you're doing that, because doctors can get involved in other ways, but anyway, to politely let them know. If that doesn't resolve the issue, then the only thing you can do is go before the judge, which you do by filing a motion and having a hearing. When you get to the judge is going to make the decision, and typically they're going to want to hear from experts. They're not going to just take the parent's opinion and weigh and make a decision. They're going to want to hear from experts. And then in making the decision, the judge either might make the decision himself, but more likely he will assign one parent sole parental responsibility just as it relates to that one issue, because someone's got to make a decision. And in deciding who gets sole parental responsibility, very often it's the parent who's been the most involved in the child's medical care. So my advice would be, starting today, to get as involved with your child's medical care as you can, which would mean contacting physicians and also scheduling and attending any necessary medical appointments. You know, I would at least thoroughly explore all opportunities for getting an attorney involved, and ideally, if you have more money, get an attorney who you know is going to be thinking carefully about your case and really strategizing with you every step of the way. So.
What if there is no petition of dissolution of marriage yet? Let's say the parents have decided to divorce and one of them puts the child on the drugs.
Well, in that case, the first thing you want, you're a parent, you both have equal rights, and so again, I would be contacting the physician, writing the physician letters. You know, then there are things you could file in court, but if you're planning on getting divorced, the best thing would be to file a petition for dissolution of marriage or get into some sort of temporary settlement agreement. That there are temporary, I didn't want to get into, there are temporary and permanent shared parental responsibility agreements. And those are actually important, because if the temporary one is working, then the judge often won't rock the boat. So you want to be in the position you want to be in long term in that temporary agreement. But in any event, if they haven't filed, then, I mean, the main thing would be contacting the physicians. Many providers will not, you know, it's like a hot potato, that one of the two doesn't want me here. And so, yeah, I would suspect that might have a lot of effect. But if not, then you just got to get a judge involved and go against your spouse, because they're the ones. You know, you either control the spouse or you control the doctor, and you can control the doctor. You can, and you control the doctor by sending him a letter. You can control the spouse by, you know, going to court. Otherwise, you know, like it or not, the court is kind of like watching you, and they watch you through. It's not like Big Brother, but there are witnesses to your life, and attorneys can reach those witnesses. So pretty much you need to be on good behavior. You know, it's frustrating, but you need to be on good behavior when you're involved in divorce litigation. And that means, you know, no stalking, screaming, yelling, threatening, not violating repeatedly the shared parenting agreement. I'm not saying that would lead to a psych evaluation, but just you don't want to have socially inappropriate behavior. And so my advice would be, you know, you just got to kind of zip your lip when you're involved in, and be, you know, very cautious about the things you're doing and saying. You just need to be careful. And then I just want to add a couple footnotes at the end. And one is that this is just like a general discussion, and I can't give advice on any particular case without knowing the details, because these cases are complicated and one fact could change what I have to say. And the other thing is that because there's more to say on this, I'm going to add more information on my website, which is new and under construction, but I will add some more details that I didn't discuss today on my website, which is tinawillis.com. So, and also thank you to you guys for letting me come here today.
Well, thank you, Tina. It was a pleasure. Thank you.